Welcome to Choose Courage Inc. I'm Vivianne Castillo, and today's episode is a special one. I'm giving you a sneak peek inside the Choose Courage Inc. entrepreneurship community. And so today's episode is going to be a fireside chat that I hosted within that community with my business coach, Patrice Perkins. I've been working with Patrice since 2020, and I'm so thankful for her and to have her as my attorney, because I think a lot of times attorneys kind of treat you like a checkbox on their list, just another thing to talk to or to deal with. But Patrice has really and truly been a strategic business partner to help me protect, grow, and think more intentionally about the businesses that I'm building. And so in this conversation, we get into the legal side of entrepreneurship in a way that actually feels practical. We talk about the mistakes entrepreneurs make early on, how to think about protecting your brand and intellectual property, and what's actually worth investing in when resources are tight. We also spend time unpacking something that's on a lot of people's minds right now, which is AI. I don't know if you've heard of it, AI. And we get into who owns what you create with it, where the legal gray areas are, and how to think about protecting your work in a rapidly changing landscape. And so this was originally a live session with our community. So you'll hear moments of back and forth, examples. We're asking people to drop stuff in the chat and real questions from people building businesses in real time. So if you're creating something, growing something, or even just thinking about starting something, this conversation will help you take your work and your ownership of it more seriously, thoughtfully, and strategically. All right, y'all, let's get into it. All right, y'all. Welcome to our attorney fireside chat with my amazing attorney, Patrice Perkins. I've been working with Patrice since 2020. And one of the things that there are so many things I really love and appreciate about working with you, Patrice, but one of them is that you're not just coming to me and we're not just like talking about legal advice, but you are a really great partner in terms of business strategy and development. We have a bunch of questions to be working through today. A handful of them are things that were submitted from folks in the community. And then I also have some AI specific things because I guess that's a popular thing these days. So we're going to dive into some of the legality issues as it pertains to AI. But before we do that, I just wanted to give you a few minutes just to introduce yourself, share a little bit more about your background, the kind of work you do. What's the tea?
Yeah. Good evening, everyone. What's the tea? My name is Patrice, and I am the founder of Creative Genius Law, which you see here on the screen. And this is a firm that serves essentially creative geniuses. And so the first question I usually get is, well, am I a creative genius? What is a creative genius? And a creative genius is geniuses in creative industries, or you might be in a traditional industry, but you take a creative approach to your field. You're usually looking to shift the way things are done in your industry. You're a change maker of sorts. And so that is how I define creative genius. You'll notice that a lot of law firms out there are named after the founder, and there's nothing wrong with that. But I intentionally did not name this firm after me because I wanted people who I met every day, who I knew were geniuses, to become comfortable with using that terminology to describe themselves. And so I wanted people to be able to recognize what I consider to be their everyday creative genius. And so that was very intentional. That brings me to the work that I do. And so the work that I do is really in three main areas. I work in the area of intellectual property, specifically trademark, copyrights, and trade secrets. I also work in the area of contracts, so any sort of contracts that need to be reviewed or drafted. And then a big piece of my work is also deal negotiations. And so for me, getting people to recognize their everyday genius immediately, like when you see my brand name, helps by the time they come to me to negotiate deals, because when I tell you you need to charge more, then you are more willing to stand behind that. So ultimately, my purpose here is to help people protect all of your creative work, to profit more from your creative work, and to ultimately build the legacy that you desire. We all work so hard. And the beauty of IP specifically is that ultimately your IP can go to work for you. And that's what my big kind of hairy goal is for my clientele.
I love it. I love it. And I know a lot of the folks who are tuning in today are maybe earlier in their entrepreneurship journey, whether it's within a few months or even like a few years. And I know you have seen a lot of things within the work that you've done. I'm curious about maybe if you could share, maybe kick us off with what are some of the legal mistakes that you often see new entrepreneurs make over and over again? And even just some context around what do those mistakes end up costing them?
Yeah, so really it's an identity mistake, a legal mistake, more of an identity mistake. And what I
Mhm.
mean by that is that, and I've seen this consistently, I've been in practice now for 16 years. And what I consistently see is people struggle to recognize their value. All right. And so that's why I say it's an identity issue. It plays out in contract negotiations because typically people are valuing what they offer way too low and they struggle to advocate. Because of that, they struggle to advocate for themselves in a negotiation process or to engage in real negotiations. And then from the IP perspective, it plays out in people waiting until someone else tells them what they've created is really good and has value. So they wait for the market to attach value. And a lot of times it's too late. So usually it's a value issue, and that leads to people waiting or being non participatory in the process of advocating for themselves.
Yeah, yeah, yeah. I mean, it makes me think about I remember there was one particular contract that you were reviewing for me. And in the contract, you kind of opened my eyes to see that I was not only undercharging, but some of the terms in the contract would have given ownership of my IP to the client. And I know like when it comes to legal things and even just investing in your business, money's tight. So we have to be very wise in terms of our cash flow and where to invest. But what are the decisions that actually matter early on that people should be thinking about some element of legal investment versus the stuff that people tend to waste time and money on too soon?
Yep. So the biggest category for me is protection of the brand. And that's where trademarks come in. And the reason for that is because once you've invested in what it costs to develop the brand in the first place, rolling it out into the market, nurturing an audience that has become loyal to it, you've already got an investment. And so by that point, you want to make sure that your brand is not vulnerable in that you are accidentally infringing on someone else's mark. And so I've had people come to me after they have become very attached to the brand they've developed. Maybe they faced an infringement issue that, they didn't know existed. And now we're dealing with a possible rebrand plus those additional costs that come along with any sort of legal dispute.
Mm.
So I would say investing in protecting the brands or trademarks is the biggest area for me. Second biggest area is actually getting someone to guide you on your contracts and negotiating your contracts. The challenge, especially if you're a provider who tends to work with the same clientele over and over, is that once you enter a contract with specific, financial terms and intellectual property terms, once you do that, what you develop is precedent, meaning when it's time to then negotiate a new contract with that same company, they are looking at what you did prior and wanting to lean on that as some sort of a benchmark. And so if it was negotiated in a manner that actually wasn't in your best interest, then what you've got is a poor benchmark that now your client is looking at you and saying, well, that's what you gave us before. Why are we making this leap now? And so it's very important to kind of start early on with terms that are protective of you and work in your favor and that capture your value.
Yeah. Let me give some examples for y'all listening. I remember, so I have a pet astrology business called Moon Paws, but in the beginning, we wanted to call it Pastrology. I thought it was clever. I thought it was cute. And we had really attached ourselves to this name. And we ended up working with Patrice to help us understand trademark possibility and if this is something we can move forward with. And after Patrice did research, she came to us and she's, nah, girl, you got to change this name. And I mean, you could technically pursue it, but it could be really expensive. And being so early on in the business, honestly, isn't going to be worth it. And I'm so glad that we talked to Patrice about that first instead of buying the website, branding everything, building a product and using it. only to then find out later that we wouldn't be able to trademark it and we could potentially be putting ourselves at legal risk for building a whole brand around it. So we ended up renaming it to Moonpaws. That was a huge thing that she had helped us with. And then in terms of contracts, there have definitely been, I'm thinking of a couple instances, I'm sure you're remembering these, where the contract saved us in terms of some of the legal issues that came up later. Because the contracts, again, help protect you, but also protect your brand and your IP. And we had come into a disagreement with one of the contractors that we were working with, and they were asking for terms that weren't going to be favorable to us as we ended up needing to go our separate ways. But the contract actually protected us and allowed us to actually own a lot more of the IP and the things that we had created in that partnership.
Yeah. And I think you posed a very good question around those initial costs because that's a natural concern for a lot of people, I would say, especially in today's economy. And so, one of the ways that we actually work with clients is you shouldn't stay in defense mode forever. I actually don't enjoy like the firefighting. What I want to do is help you protect what you've created on the path to then monetizing what you've created or monetizing it more smartly or more passively or whatever term you want to use. And so we actually, for the clients that work with us on a recurring basis, we try to switch between protection projects. So things like making sure you own the trademark, your contracts are ironclad, to then looking at what it looks like to monetize your IP. So we're
Yeah.
kind of going back and forth between the two versus always staying in that defensive mode.
Yes, yes, yes. And I do want to dive into the AI conversation, but before I do that, I think it's just going to be a helpful refresher as well as kind of establishing a baseline for folks to understand the difference between copyright and trademark. So I'm wondering, can you just break those two down for us so that way we can better understand the AI conversation in terms of protecting our business?
Absolutely. So at the highest level, what intellectual property is an original creation of your human mind. That's the most, basic watered down version, right? Original creation of your human mind. And then within that, we have a few categories of intellectual property. So what trademark is trademark protects essentially anything that identifies your product or service to its consumers or in the market. And so that is going to be your logo, your brand name, your slogan, in some instances, a color and a smell or a sound, right? And so the key is that it has to identify your product or service to consumers. All right. And then copyright broadly is an expression of an idea. And what that means is you've taken an idea, an original idea, and you've put it in tangible form. So you've put pen to paper, you've recorded the original podcast, you've written an original book, you've written the original source code, you've taken original photos, whatever that is for you. That is what copyright covers. And so the body of intellectual property and the other areas are trade secrets and patent law. What that does is give you a body of laws that protect all of your intellectual property, AKA your intangible assets. These are assets in your business and they're just intangible because it's not like it's your home that's paid off and you can touch and feel it all the time. It's intangible because there are these invisible rights that attach to it.
Okay. I'm gonna throw some examples at you, and I would love to hear, is this something that I would trademark or something that I would copyright? So let's say I have developed an app. Is that something I would trademark or is there something I could copyright within that?
Okay, so the nerd in me gets really excited about this because I love trivia. And even though I know all the answers, it feels like, well, trivia, legal trivia. I think we should actually ask the room. So if anyone is up to popping can they chat?
Yeah, yeah. So in
I
the
know.
chat, do you think a mobile app is something that you could trademark or copyright? And if you're listening to the recording of this, I want you to think about your answer as well. All right, we're having a little bit of mixed.
Yeah.
Some folks are
Yeah.
saying bold, some are so yeah, what's the answer?
So the answer is both. So the branding of the mobile app is what would be protected under trademark law
Okay.
because the brand identifies the service or the product, right? And then your copyright, your source code to the extent that it's original, is what is going to be protected under copyright law, or even the visual elements of your mobile app. So if the layout of it is original, then that can be protected under copyright law.
Okay. I love it. Next quiz, folks, put your answer in the chat, or if you're listening, think about your answer. If I am, let's say I'm working with a company as a consultant and I'm creating, curriculum for us to work through, workshops, custom talks, what have you. Would those be things I could trademark and or copyright? What do you think the answers are, everyone? This is like training materials that I'm creating for a company. So like a B2B kind of client. What do you think? Put it in the chat. Someone says it still feels like both, especially if you're attaching your brand to the materials. I have a few folks are saying copyright.
Yep.
So Patrice, what's the answer to this?
The answer is all of the above. So the brand attached to the materials. When it comes to education and training materials, copyright law gives protection, but there's a higher level of protection for material that is highly creative. And so the law doesn't tend to look at education and training materials as highly creative as some other forms of work. And
Okay.
so you would have some protection under copyright law, but also what kicks in for you is your contracts. It closes the gap because then you can have confidentiality language for the people who take your course.
I love it. Yeah. And this is, again, contracts are really important for this. So you can protect even pre-existing work. Because for a lot of my consultants and whatnot, a lot of your clients will hire you as works for hire. But in your contracts, you want to make sure that you're protecting pre-existing work.
Mm.
Yeah.
It's a big one.
All right. Another pop quiz. And I remember being surprised at this when you and I were going through it. So I have this business called Moon Paws. This is my pet astrology app. And we created a little character, kind of like a mascot, so to speak, for the brand. We call him Orbit. He's super cute, very popular. Is this something that I can trademark or copyright? I'm curious in the chat what you think. All right, I see a trademark. Trademark my cute little Orbit mascot for my business. Trademark, okay. What's
Yep.
the answer, Patrice?
All of the above. So the
All the
reason
above.
is,
Okay.
yes. So the reason is, so because this is a character attached to a product or service,
Mhm.
right? And as the product or service becomes more popular, people will start to associate the character with it directly, then it can still get that protection. So if we think about, Mickey Mouse, Minnie Mouse, incredibly famous trademarks, right? But then the work of art. So the work of art is a little bit different. It's literally tied to it just being an original drawing that gets copyright protection. They both protect in different ways. Trademark has to be attached to a product or service. Copyright doesn't necessarily have to be attached to a product or service.
Okay. I love it. All right. So
And
hopefully
we
y'all are
did
getting,
both, right? We did both.
yeah, we did both. Okay.
Mm.
So hopefully y'all are getting a sense of what aspects are trademarkable versus copyright. But I think the main takeaway is your IP is very valuable and that there are ways to protect it. There are ways to act on it, and doing it through these two routes is how you can approach that. With that in mind, I do want to start having this conversation about AI. I guess it's a popular thing these days that people are talking about. And I know that, for me, it's if you're using AI tools to help create content or courses or client deliverables, can you talk to us about who actually owns that output and where the legal gray areas are right now? Because I know a lot of things are still evolving right now.
Yeah. It's a little bit of the wild, wild west. So the legal industry is still figuring it out, and it will take some time for it to do so. But what this ties to mostly is are you eligible for copyright protection as the owner of the work? And are you even considered the owner or the author of the work when there has been AI involvement in the process? And so one thing that's very important for you all to know is that copyright law actually requires the owner to be human. And there have been arguments made that the interpretation of requiring a human author is archaic in today's world. But the
Mhm.
reality is that the copyright statute never contemplated that an author could be anything but human. And so until the statute evolves, if it evolves at some point, right now, an owner has to be human. And so the Copyright Office, your answer is going to be, complicated, but the number one is it's supposed to be human. And so then, what role does the technology serve? Does it then kind of supplant the human author as the creator? And if so, what does that do for copyright protection? So the Copyright Office has put out a couple of great resources on it. They're still figuring it out. And what they have done is drawn the line so far between work that uses AI to create reference material,
Okay.
right? To help guide maybe even like the research and reference process. And then the human still goes and creates the final output.
Mm-hmm.
When that is the case, then Copyright Office is more likely to say, yes, you can get art protection and all of the benefits under the law because you only use this tool to assist in the process, but it didn't create your final output. Now,
Okay.
where we are actually using AI to create the final output, right now the Copyright Office is landing at no. And I actually have something that I want to show you guys around that.
Yeah, that'd be great.
Yeah, let
He's
me.
just gonna share his screen to shine some more light on this.
Yeah, and so because this is all relatively new, what we have right now as an example is actually like from the visual art space, but it'll help illustrate where the Copyright Office is landing at. So what I want to point out for you first is that copyright ownership is really important because when you have created work that where you are the copyright owner of it, it attaches the moment that you create the work and you put it in tangible form. What that means that you own is the exclusive right to control whether that work is republished, reused in any way, whether spin-off versions of it are created. And that right lasts your lifetime plus 70 years in most instances, your lifetime plus 70. And so when it comes to eventually wanting to monetize our creations, that right attaches back to the copyright owner unless you've given that right away. So if you're now creating work with AI is creating the final output. The issue is the court right now is saying, in the Copyright Office is saying the machine essentially is the owner and not the human. And they have been rejecting some applications for that reason. So where they have drawn the line is like there's this whole discussion of prompting that I'm not going to get into, but I'll give you the name of, you can pull the name of this resource, which is a public resource. So they've done this whole exploration of prompting because people wanted to know, well, if I get really intentional and specific and creative with my prompts, does that mean that I then own the final output? I then created the final output. And what the Copyright Office is saying no, because no matter how specific you get with your prompting, there's still a lack of user control over the end product. And so this is the example they give. This is an example of a prompt that was put in, right? Very specific. Bestacked a cat in a robe, reading the Sunday paper, very specific. And so what the Copyright Office basically said, and then this is the output, right? What the Copyright Office basically said is that where no instructions were provided, AI still fills the gap. And they also say that the output of this can look a number of different ways, right? We can put this prompt in Claude, we can put it in ChatGPT, we can put it in Gemini, and we get a different cat. And what that tells the Copyright Office is that the machine is the creator. That's the challenge. So right now, they're landing on me. You put it in prompts, and they have a section of this that really, they kind of go in a little bit because they're like, we don't care how much blood, sweat, and tears you put into your prompt. That's not what copyright law protects. It protects the human author of the work. So that's kind of one example where they're drawing a pretty clear line. Now, where they treat this differently is here. So this is an example of someone who has input their original work into whatever platform you're using, ChatGPT or Claude. They've given the prompt alongside it, but they've uploaded their original work. And then the output is basically an iteration of that person's original work. All right.
Mhm.
Everybody following it so far?
Yeah. So, and for those of you who are listening to a recording, what we're looking at right now is this is coming from the U.S. Copyright Office. So, if you Google U.S. Copyright Office, copyright and AI, we're looking at kind of like three things on the screen. One is a prompt. One is one of the inputs, which is a sketch that someone did, and then the output is like the AI generation of that sketch.
Yep. So, what the Copyright Office basically said here is that because the input was clearly human created, now they're looking at the output as more of a refinement. And in this case, the applicant was able to basically claim copyright ownership of the work, but they had to kind of exclude the things that were machine generated. But there is more kind of leniency here in terms of it being human created. So the way that that relates to your original question is if someone is actually providing their original curriculum to the machine and saying, "Hey, I want you to edit, prove, make it more, engaging, whatever," in the output is based on that original input, then you probably will have more protection. But then we have other risks, right? Because then now it's
Yeah.
the machine training on my original creation, which is a risk you'll either take on or you'll decide not to do it at all. So,
Okay. I just want to take a moment to touch on something before we get back to the episode. Now, a lot of what we're talking about in this conversation comes back to one core idea, and that is recognizing your value early and not after the market tells you. So, protecting your work, charging appropriately, making intentional decisions about what you're building and how you're building it. That's not just legal strategy, that's identity work. And so if you've been listening to this episode and you're starting to feel this nudge, like you know you're ready for something more, but you haven't fully acted on it yet, I want to invite you into something I created called The Walkout. The Walkout is Wednesday, June 3rd to Friday, June 6th, and it's for people who are ready to leave what no longer aligns and to start building something that actually reflects who they are. It's not about impulsively quitting your job. It's about making a clear, courageous, and strategic transition into your next chapter. If you've been sitting on an idea, if you've been second guessing yourself, if you've even just been waiting for quote unquote the right time, then this is your invitation to stop waiting and to start moving. You can learn more and sign up at jointhewalkout.com. Link is also in the show notes. I would love to support you in taking that next step. All right, let's get back to it. So, what I'm understanding is you will have better protection if you, let's say, input like an original work of yours, something you originally wrote or something you originally drew, what have you, versus creating a very elaborate prompt. And the argument is that if I put that exact same prompt in ChatGPT or Claude, I'm going to get two different images, which means that it's the machine AI that is having more of a contributing role to the output and creation
yep.
that is on the screen.
Yep.
Okay.
And I want to say I'm not advising anyone to upload their original work to AI because again, like there's different level of risk along with some benefits, right? That come with using it. And so what I think is it takes a kind of a strategic approach to it to figure out where the risk might be worth it for you versus where it might not be worth it. So if this is like your most valuable part of your curriculum, you don't just want to feed it to AI because it's going to become a part of the learning model. And that is a separate issue that's actually currently being litigated by the courts right now. So,
Interesting. So then I guess how should entrepreneurs think about protecting their original work from AI? Because if someone's built, let's say, a proprietary framework and it gets scraped for training data, is there any recourse that is able to be taken?
right now, there might be more than one, but there's one big class action suit involving a bunch of authors of books whose work has been scraped and used for training in AI. And a settlement has been reached in that lawsuit, which will be paid out later this year. So the courts, and that was really like the first big case. The court is currently hearing cases around, is it fair use for ChatGPT to scrape your proprietary information, or let's just say your original information, and use it for the learning model? And the courts are hearing cases around that right now. So the answer is we don't know. What
Hmm.
I recommend is, if copyright ownership is important to you, which I am an advocate of it being important for everyone, then you create on your end. You maybe use the support of AI for like your research and maybe forming some of your thoughts. So even like outline and all of that, but you actually do the creation on your end. And if you're looking to use it to refine, I would not upload your entire creation into AI. I would do nuggets of it at a
Okay.
time.
Okay. Okay.
Does that
Yeah.
make sense?
Yeah, it's making sense, and it's
Okay.
also making me think about just, like, a blatant, like, red line example is I think Grammarly just got in trouble for this, where they basically were creating these bots from, like, the work of authors living and those who've passed to give advice and training on your writing, and they
Mm.
hadn't asked any of these people if their works could be
Wow.
trained on it, if they could even represent their likeness, like, it was just
Right.
bad, bad, bad. I guess what's coming up for me is, especially for anyone on this call, anyone who's listening, who is building AI-powered tools or products, can you maybe walk us through, again, maybe just some of the, like, the legal considerations around data privacy and liability that people tend
Mhm.
to overlook?
I would say whatever whatever you consider your, first off, this is a tough question because it's, it's all still
Yeah.
developing and I'm still wrapping my head around it. But I would say whatever you consider your secret sauce to be. So you might have a name for a framework you've developed. You might have something that really is unique to your process. I wouldn't feed it into AI verbatim, because right now you can assume that it would become a part of the model for everyone else. Doesn't mean that you lose ownership to it. Ownership is not actually the issue here. It's the reuse of it, the repurposing of it for all of these other people, and how that might show up on the other people's end. So I would say be really intentional about not revealing your secret sauce. I would more so use AI to follow a line of questioning around certain things, but I wouldn't just give it like your secret sauce. In terms of the data and privacy, when I last read everything in the model, I was going to say, when I last read, I don't think it's been updated because I read chat's terms and everything in the model. Actually, they said that, okay, so it seemed like there were some privacy protections, but at the same time, it seemed that everything in the model was kind of equal territory, meaning that it could be reused for training purposes. And so I would say that even their terms aren't protective. And so it's one of those areas, here's the thing, it's not any different than when we first started really like promoting businesses online and sharing our work online. The digital landscape took a long time for the law to catch up, and the law is still catching up. But we figured out a healthy balance of sharing, but not giving away our IP. A lot of people did. And so this is similar. And the general approach for me is just to be conservative. Use it as a thought partner. Don't give it like your top secrets. If you're using it to create tools, stay away from the Grammarly example of, I want to build this tool using the methodology of so and so. It don't do that. Use whoever so and so is, use that to inform your methodology, and then ask your tool questions, or whatever platform you're using, questions to help you refine and reiterate and make it usable for other people. But don't just pull someone else's known methodology and create something based on that. Because if it's not an issue now, it may come back later.
Yeah, yeah, yeah. Something that's making me think about this is maybe more of a personal notation of as I've been watching the landscape with AI and technology as an entrepreneur, as a creative, I'm like, I have to be a lot more intentional in nurturing my intellect, my creative ability, and not to create like a over codependency on AI. And I think as this continues to play out, people will sense, what is being run through AI. They'll sense what is lacking thought and intentionality and uniqueness and creativity. And so my encouragement for y'all is, again, like, AI can have its place in business and in the world, but it's really about, as the entrepreneur, as like the source of the creativity, how am I going to nurture that and protect that? How am I going to show up in ways that are honoring that for my customers, my clients, and the shape and form of my business? So just something to be thinking about. To that end, though, we did
Can
talk
we
about,
can we stay there for one quick second? I want to
yeah, yeah.
offer a flip side. Okay, so the flip side of it is when you're hiring people. So if you're hiring people to do work for you, so it might be writing or other creative work, one of the ways that AI has changed the game for us as business owners is now you should consider having language in your contracts with them that asks them to disclose if they're using AI to do the writing, AI to do the research. It doesn't mean that you completely prohibit it, but they need to disclose and disclose how they're using it. For instance, you
Mhm.
may be giving that contractor access to your confidential information in order to fulfill whatever the job is, right? Well, what if they're then going and uploading that to AI to help create a marketing plan? You might be okay with it. You might decide you're okay with it, but the fact is that you need them to disclose it so you can then make an informed decision around it. So that's one consideration. Another consideration is I actually just worked on in the middle of a big publishing deal for a client, a big book publishing deal. And one of the questions that she has for the publisher is, will you be providing access to my manuscript for the purpose of AI training? I want to make
Mhm.
sure that it doesn't land somewhere that the publisher kind of had control over. And so we have to, as business owners, start to think about how what we provide access to may be handled differently by other people in this day and age. And so think about that in your engagements with contractors.
Ooh, that's good. We'll have a separate conversation, Patrice, about refreshing some of my contracts to
Mhm.
include
Yeah.
some of that clause. But yeah, that's really good. You had talked about trademarks, you talked about copyrights. Can you maybe be more specific on what are then trade secrets?
Yeah, trade secrets are actually my favorite. So, trade secrets are defined by state law, so it's gonna be a little different depending on where you're located, but the general definition is anything that you consider to be a secret in your business that has economic value or that potentially has economic value. Common examples would be formulas, research and development data, vendor lists that are like highly vetted, and researched, price lists that are highly vetted and confidential. And so essentially it covers the gap where trademarks and copyright don't give you any protection. And the way that you protect a trade secret is literally by keeping it a secret. The reason why I say it's my favorite is because trade secrets last as long as you keep it a secret, so it can be forevermore, which is why a lot of the powerful brands that we know also rely on trade secret law. So two famous examples would be the Coca-Cola formula is maintained as a trade secret. Also, the Kentucky Fried Chicken seasoning for anyone who still Kentucky Fried Chicken always takes me back to the 90s, but for anyone who still eats Kentucky Fried Chicken, that seasoning is a trade secret. Trademarks last as long as you continue to use them, but you still have to go through a renewal process. Copyright law already gave you that time frame, but that does run out, even though it's way in the future. But trade secrets last as long as you keep it secret. And you do that with confidentiality language in your contracts that protects them as secret and making them available on a need to know basis.
Okay, okay, okay. I'm tracking. I'm picking up what you're putting down. I mean, I imagine for folks who are listening to this, there's potentially a little bit of overwhelm that might be happening in terms of all the things that can be protected when it comes to ownership, right? Business names, colors, even, right? Like you had talked about, like T-Mobile's color is like a good example of something that can also be protected and is very unique to them. I know other folks too have thought about things like, website domains, social media handles. So there's so much to think about when it comes to ownership. And I'm wondering if maybe you can offer just a little bit of guidance around how should someone approach securing all of kind of like these ownership pieces? And I'm imagining some folks are thinking about what happens if I skip that step and someone else grabs, a domain, even though I've been using this brand name for the last year and a half.
Mhm. It's a never ending school project. So that actually always, I can see when people slip into panic with me. And so I always tell people, you can't do everything at once, right? And so some things that you introduce into the world may be more like experimental to kind of see how your consumer responds, to see how you like whatever that thing is, and then to make a decision about it. So for those things that are more experimental, I would not necessarily put those in the top category of protection. But what you do want to do is give yourself a timeline to make a decision about it. So is this going to make
Mm,
it into my permanent offerings or as a part of my permanent, brand identity? So give yourself like maybe a quarter to assess and then come back and make a decision. The things that you want to start with for protection purposes are going to be the pieces of your brand that are core and more permanent. So that goes back to whatever your primary brand is, right? You want to protect that with trademark, period. Like that's going to be most important. And I would say you want to start that process as soon as possible. From there, what I often see is people developing a lot of spin-off brands, partly because people get excited about creating. And I actually discourage people from, trying to protect everything too soon because not everything is going to stick with the consumer. Some things may be very like of the in the moment, so very like trendy for right now. So you want to give yourself some opportunity to test and see what sticks. And if things are still sticking 6 months or a year later and sticking in terms of like visibility, it's really gaining traction, then there will be a decision made about whether to add additional trademarks. From a copyright perspective, what I'll say is once you have solid contracts in place, and even if you're running a group program, solid terms of use for your members and all of that, that protect everything that you own, you don't have to worry about each new thing that you protect. What I typically would guide people through for the copyright protected material is identifying what has the highest value in terms of what's most unique to you. If your competitor popped up and swiped part of these materials, which ones could possibly harm your business the most? So we go through just an assessment to figure out what the top priority is, and then we just gradually move through over the years. And for people who are constantly creating, you may not ever register everything, but what you want is the things that carry the most value in terms of maybe even emotional attachment, financial value, and its place in the market in terms of your competitive landscape.
yeah, yeah. And it's making me think about, especially for the folks who are listening, who maybe they're creating a lot of content on YouTube, podcasts. Maybe they're even working with contractors to help them edit videos or helping them to write things. I guess with that particular example, just because I know we have a lot of those folks who tune into things that we do, how should they go about protecting themselves and their IP when they're working with contractors?
Mhm.
Especially if the contractors are having somewhat of a creative hand in the creative process.
Yeah, that's a great question. So, first thing is going to be making sure you clearly define the role of the contractor. So, I've had situations where actually a question I asked someone recently who was working on a podcast and someone else was heavily involved. I said, "Well, is this person a co-founder of the podcast or are they, a contributor to the podcast?" And the person said they're a contributor. I said, "Well, the way this role is described right now sounds like you guys may be carrying, kind of equal weight. And so we need to really kind of refine what that role is and pull it back a bit." And so being really clear around where their role starts and stops and what your role is, making sure you have contracts with them, which may sound like obvious, right? But the key is when you're working with contractors, unless you have a written contract with them, by default, they own whatever they create. There are some very few exceptions, some exceptions, like a movie would be the exception, but usually they own everything they create, which means they're considered the copyright owner as a contractor. So you have to, and you can't have them sign work for hire agreements retroactively. There are other ways to kind of deal with that, but you want to make sure you have a written agreement that clarifies that what they create is work for hire, meaning everything is outright owned by you or your company.
Mhm.
For anyone appearing on the podcast, so your guests that you are interviewing, you want to make sure you have a release for their appearance, and that release should also grant you ownership of the actual, recorded episode. And then from there, once you have your paperwork in place, it is registering with the Copyright Office. And so there's different processes depending on the type of original work that's being registered. And for podcasts, what I recommend is a 3-month cadence because that lines up with some of the benefits in the copyright statute that you get, including the opportunity to recoup attorney's fees if someone infringes on your copyright. So I handle this for clients and I do every quarter, I'm registering the copyrights for all the podcast episodes from the quarter.
I love it. And I think what you're shining a light on is truly like how valuable our creations are. Like, y'all are creating some incredibly valuable things. And so I appreciate you kind of walking and breaking down how to protect that and recognize it for what it is. And, I think another thing in a similar vein that tends to pop up is, especially for folks who are in corporate, they're trying to leave, do their own thing. I know like non-competes, these kind of like these clauses in our employment contracts can be a source of real fear for people leaving corporate. And I know you've dealt with this as well, but with some of your clients, but what do you wish more people understood about kind of like navigating those on their way out, especially if they are wanting to, let's say, create like a consulting business that has some parallels to some of the work that they were doing internally with their employer?
Hi, my name is Patrice, and although I may be an attorney, I am not your attorney. So this following segment is for educational purposes only. And so what I'll say is one of the questions that I ask people when I know that they're planning their exit is what they signed when they came in. And a lot of people don't remember. And so you can start re-familiarizing yourself with what you signed when you came in. So a lot of times some people, when they are lucky, what they've signed is I don't know, sometimes what the employer might have had you sign is actually something that says that even if you have pre-existing IP, like all of it belongs to the employer if it's tied to the nature of the job. And so you want to go back and look at that original paperwork and be clear on what you signed. That's the first thing. Second thing is it will help to become familiar with what your state says around work for hire. Most states say that the employer owns the work that you create as long as it's within the scope of your job duty or like reasonably related to your job duty. So that can become kind of like your measure. So if you're doing something outside of work that's totally different, then in a lot of cases, you will be okay. If it's related, that's where it gets gray because different states, depending on how the courts have interpreted this, might interpret related to be very narrow or it might be very broad. And so, if that is your case where you're launching something that's pretty similar to what you're doing on the job, you want to not be using customer company equipment, company time. You want to be very careful about company contacts. And quite honestly, I think that you need a friendly ghost in the background to actually do the work for you until you're able to make this transition because you're probably at the biggest risk of the company then claiming ownership to what you've created. So to recap that, revisit what you signed when you came in to that particular job. Take a look at your state's work for hire law. You can kind of Google to figure out like what do the courts, say, how do they define it? And then consider whether the work you're doing and what you're creating outside of work is considered related or not. And then based on that, you may want to consult with an attorney at that point.
Yeah. I'm curious if you can think of like an example of this with someone and their employer and that, lines were crossed, things got kind of gray. While you're thinking about that, I'm thinking about how when I started Humanity Centered, I again, was at this place of recognizing, okay, this could be a business, and I wanted to protect it from Salesforce. And so when I looked at my contract, my agreement, I learned that I had to basically get approval for building this business. And so Salesforce could then okay that it's not in conflict of interest. So initially, when I had submitted that paperwork, Salesforce actually denied it and said that it was in conflict of interest. But I ended up pushing back and explaining, here's how it's not, and here's what they can expect. And they approved it. But if they didn't approve it, then I could have been the things I was doing with Humanity Center could have then just been owned by Salesforce. So I remember I had to go through that legal step just to make sure T's were crossed, I's were dotted. Exactly. Did not want to give Mr. Benioff any of that. And it was really important, especially because I knew further on that this would be like the core aspect of the business I was building. Patrice, you have any other examples that come to mind of where you,
Mhm.
yeah, yeah.
Yeah, I had a big case around this several years ago. I had a client who had, it was right in the height of the blog era, and the client had started and grown a really popular blog while she was working somewhere else. And she actually came to me for the trademark. And when I got ready when I went through the whole trademark process and clearing it to make sure it was available to her, I said, wait a minute, your employer has already filed an application for this trademark,
Oh
which
my
then
gosh.
kicked things off. And so we had to go to the employer about it. And she was, on her way out of the door. We had to go to the employer about it. And the employer basically said, we're a media company and she created this. This was work for her. She created this on the job and we own it. And we fought over it. And what I ultimately was able to show was she was like an, let me say, like an editorial assistant. And that particular job title was not typical for the industry for them to be launching whole verticals for a media arm. So I basically used her title and the junior nature of it to argue that no, this was not within the scope of her job. No editorial assistant would have, created this new brand. Her salary wasn't, commensurate with it. And ultimately everything was decided in favor of my client and they withdrew the application. My client was able to proceed and she did ultimately quit and still run that blog. So that was a huge one. We had another one where it was another media company and the client actually owned the IP before she started with this company. She started, let's just say, a multimedia platform that had become very popular before she became an employee. They got wind of it. They offered to buy it from her. And she said yes, because it felt like a lucrative opportunity for her. She said yes. And they wanted to hire her to run it. And she said yes. So they paid separately for the asset. Then she got her salary as an employer. And then fast forward years down the road, she's ready to leave and take her podcast. Oh, okay. This is just within a small community. Take her multimedia platform with her. And they said, no, you can't take it with you. We, we bought that and you were hired as the host of it, so you can't. And so that was when we actually were not able to sort out because the trick was that this was a nonprofit. And a nonprofit has restrictions where if they dispose of assets, they have to dispose of them to another nonprofit. So they couldn't just hand it back to her. And so that was one where we were not able to resolve to her satisfaction. Actually, we did reach a resolution, but it was not to her satisfaction. And it was because of, everything that's taken place. And so these companies are not afraid when they see that something has value and that you've got a
Hmm.
following and quality content, they are not afraid to stake their claim to it.
That part.
Yeah.
Yeah, I mean, I remember when I was building Humanity Centered, I had a colleague who was like, I feel like you're overreacting by trademarking Humanity Centered and like your assets. Like, what would Mark Benioff want to have to do with it? I'm like, what any billionaire would want more,
Mhm. Yeah.
more. So it is important to be intentional in protecting your stuff and making sure that you're doing it well. One thing I appreciate about you, Patrice, is I know you just have a heart for entrepreneurs. I know that especially early on, not everyone can afford to have, an attorney on retainer, but they do need quick advice and they do need insight into protecting their brand and protecting their business. And so one thing that I want to share with y'all that Patrice has generously shared with me, Patrice has created something called the Lab. And I'll put the link in the chat. I'll also put it in the show notes. But the Lab is essentially a community that Patrice has created to allow you to have monthly community office hours and get your legal Q&A done with Patrice. Allows you to have ongoing access to your legal questions privately as well as receiving personalized legal guidance, giving you additional discounts into certain services that Patrice Office offers, whether that's, creating master contracts, renewing your contracts, creating, helping you with your copyright and your trademark applications, and also just providing unique legal strategy insights that can apply to your business. And I think that is the secret sauce of you, Patrice, is that you're not just like an attorney, but you are also like a business strategist and you see legal as being a core part of that. So what I'm sharing with you is Patrice is just offering a generous discount to folks within this community, folks who are aware of Choose Courage Inc., to receive 25% off on this monthly membership. So it is affordable, it's accessible to you. So if you're curious about that, please sign up in the form that I have in the chat or the show notes to just even learn more and understand more about what this entails and to see if it's a good fit for you. It's something I wish I had like super early on, but I've also been really fortunate, Patrice, to work with you really closely over the years. And you have saved my business a couple of times. That can be another podcast for another day of all of those stories. But I know we're at time. I do want to just shoot you one last question, a closing reflection from you. I know that the legal landscape for entrepreneurs is shifting really fast, especially because of AI. I'm curious about what's one thing that you think every entrepreneur who is listening to this needs to be paying attention to over the next 12 months that most people aren't talking about yet.
This is might sound very lofty, but how your intellectual property will outlast AI. So, to one of the points that was made earlier, there's going to be a point where, I mean, we already are somewhere here where we can recognize where writing that's supposed to be like creative writing and, the photos and all of these things, we can tell that they're AI generated. And that in itself is not necessarily a problem. The problem is the uniqueness factor becomes watered down. And so I would say the thing that you should be thinking about is how your uniqueness factor in your creation of your IP outlasts everything that's being created in AI. And what I say is that honestly is going back to the basics and going back to what we shared at the beginning, which is recognizing your own value, your own creativity, your own genius, continuing to center that in your work and let that be kind of the foundation of it all, and don't let it get watered down by everything that we have access to.
I love it. Patrice, thank you so much for extending your time, your energy, your gifts with us. Again, thank you for the encouragement of honoring our creative selves, our creative genius. And we just, again, really appreciate you. Thank you.
Absolutely. Thank you for having me. Thank you, everyone.
Thanks for hanging out with us and diving into some of these real and unfiltered conversations. We know your time is valuable, and so we don't take it for granted. If today's episode made you think, if it challenged you, or gave you something new to consider, we'd love for you to hit that follow button on whatever streaming service you're using. That way, you'll never miss an episode when we drop them. And if you want to go even deeper, sign up for our newsletter at choosecourageinc.com, and you'll get updates on new episodes, access to exclusive freebies, and first dibs on coaching opportunities and other resources to help you make bold moves in your life and business. So we appreciate you, we see you, and we're rooting for you. Until next time, keep choosing courage over comfort, and a friendly reminder to drink some water.